Good morning. Today is the 16th of January, 2018. We're going to continue part 5 of the Law of the Land, LORE. And again today we're going to be concentrating in the situation in Aotearoa. Like I mentioned yesterday, you were indeed blessed with the most wonderful covenant of it all. In fact, your ancestors were very, very far-sighted in securing a permanent guarantee from the clown. What's with my lisp today? I meant to say crown. But anyway, lisp or otherwise, your ancestors were indeed blessed to have secured that permanent guarantee from the crown, to make sure that at the very least, it is still possible in the South Antipodes to have two parallel governments, because that is the essence. That's the crux of your Waka Putanga, the Declaration of Independence, which begat the Treaty of Waitangi, and which later on was confirmed in the Ture Whenua Maori Land Act of 1993. Now, the preamble to the Ture Whenua Maori Land Act talks about your Taonga Tuku Iho, which I believe roughly translates to gift of God. Now, it's quite different from saying gift from God and a gift of God. Because your Taonga Tuku Iho, in your language, literally means usucapion in Latin. And what is usucapion? See, law schools don't teach you this because they don't want you to know your inherent sovereign rights. You are the most advanced indigenous people in this world because usucapion is written all over the Waka Putanga, which is, of course, the 1835 Declaration of Independence, and usucapion, Taonga Tuku Iho, is written all over the Treaty of Waitangi. Further reaffirmed with the Crown legislating the Te Ture Whenua Maori Land Act. So, this is a key issue that you must come to grips with as to your identity, as to who you are as a government of laws, LORE, laws, LAWS, and a government of men and women. It's very important that you grasp these essentials, because this is what will help you separate yourself from the fiction. See, you are the fact. You've been there from the beginning. You've always owned the land. It says so in the Holy Bible. Leviticus chapter 25, verse 23. For you are sojourners upon this land. You are not to buy and sell this land, for you are sojourners and strangers upon my land. So, and Proverbs 22:28, Proverbs 23:10, they talk about not removing the boundaries, the ancient boundaries set by your forefathers. Then the Johnny-come-lately crown comes into the picture and they introduced the torrent system, which is basically a registration system for a plot of land. Length, breadth, meets, bounds, parameter, area, length multiplied by breadth. Then they conveniently set up an office called the Registrar of Titles. Do you go there and you say, this is mine, this is mine. You know, you see this by the river, this is mine. You see that red mark there, that yellow mark, the blue mark, and the white mark, you know, about 3,000 acres, that's mine. Oh, okay. Stamp, get an ink pad going, pay the fee, there you are, you got yourself the imported legal fiction called fee simple. Well, the actual meaning of fee simple is the English translation of usucapion, ownership due to length and possession. Fee simple means the same thing. But there is a twist, you see. Usucapion is law of the land, L-O-R-E. Whereas fee simple is a legal fiction. Now, what is a legal fiction? All right, let's talk about that. The distance from Waitangi to Stewart Island down south is what? 800 miles, 1,000 miles? Find out. But in a map, it's about 5 inches. So the 5 inches represents the 800 miles or 1,000 miles. So the map is a legal fiction of a geographical reality. Likewise, fee simple is a legal fiction of a geographical reality, a moral reality, an agricultural reality, the reality called usucapion, ownership due to length and possession. You see, the crown comes into the picture. You must forgive me for my lisp, okay? Sometimes it goes crown and sometimes it goes clown. I can't control it. I mean, when can you ever control a lisp? So you got to take hold of the reality of the 24-carat genuine article, usucapion. You and yours own the land and soil 5 miles up, 5 miles down. Outright. You don't need legislation because that's a Johnny-come-lately. You need the law of the land. Now, your power and authority to own this land was already declared by your ancestors when they created the Wakaputanga, the Declaration of Independence of 1835. They made it very clear that we will frame our laws, we will take care of the preservation of peace and good order, we will engage in trade. They never said we need the permission of the great white father in Whitehall or Buckingham Palace or Westminster. All right? They were absolutely clear. If hindsight be 20/20, let it now be called hindsight is a Wakaputanga. Unequivocal, clear as a bell, conforming to the certainty of the law, L-O-R-E, of the land. Beautiful stuff. Now, there was a case, and I'm looking at it because I don't want to get another lisp. The case is called Te Runanganui or Te Ika Whenua Incorporated. Society versus the Attorney General, 1994. And the site is 2 New Zealand Law Reports 20 at 21. Justice Cook, Cooke, had this to say. He said the Treaty of Waitangi guaranteed to Maori, here comes the catch, subject to Crown Kawanatanga, their Tino Rangatiratanga and their Taonga. In doing so, they must have intended effectively to preserve for Maori their customary title. This is after the Te Ture Whenua Maori Land Act was promulgated in 1993. Now, the word Rangatiratanga means the power to control and manage resources in accordance with Maori customary practices. It's a very different concept to Western notions of what a tradition, a customary practices are. So, this is one of the interesting cases that reaffirmed Article 2 of your Wakaputanga. Now, there is a strange creature in your midst, in Aotearoa, and that's called the Office of Treaty Settlements. Ivan, Kathy, Makwini, my sister, my brother, and Ari, if you're listening, research who these fellows are. Because they are supposed to be confirming the fact that the Maori livers and rakes and lakes and lake beds and river beds and shorelines are rightfully yours under the Taonga Tuku Iho concept, which in Latin, of course, is your usucapion. So find out if they are in charge of the location of your Wahi Tapu, which is your sacred sites. Now, why would you let the clown be in charge of your Wahi Tapu? Think about that. So please research this Office of Treaty Settlements and find out what is it that they do, and whatever they are doing, they better be doing in conformity with the Wakaputanga, the Treaty of Waitangi, and the Te Ture Whenua Maori Land Act, in conformity with the United Nations Declaration on the Rights of Indigenous People of September 2007, and in line with Article 1 of the Montevideo Convention of 1933, which declares Aotearoa as a sovereign state. Because A, you have a definite boundary. 2, you have a definite population. 3, you have your legislature, your executive, and your judiciary. And 4, you have the power to enter into a treaty relationship with other countries. It's very simple. Remember that. Now, affirming the power of the Wakaputanga, the Treaty of Waitangi, was another case in 1986 called the Te Wihi versus Regional fisheries officer, 1986. The site is 1 New Zealand Law Reports 680. This case re-recognized customary Maori rights after Regina versus Simmons in 1847 and the Wee Parata case of 1877. Regina versus Simmons recognized validated native title. Wee Parata 1877, whoever the judge was said, oh, the Maoris were a bunch of barbarians. They didn't know what they were saying. They did not know what they were writing. Well, the clown signed a treaty with the barbarian. That was Wee Parata, 1877. 30 years earlier, in Regina versus Simmons, 1847, they validated customary native title. Huh? So, the left side of the mouth says something in 1847. 30 years later, the right side of the mouth gets activated and talks absolute gutter garbage. And finally, in 1986, a little over 100 years, the court says Aboriginal titles are ratified by the Treaty of Waitangi and are indeed enforceable. What is the meaning of the word enforceable? You see, you are not able to enforce the law because you don't have police power yet. All right? What did my brothers and sisters say about the police power? This is the porohau, the te hurunga, kahurie kura, the hub. These treaties are enforceable if and when your police power is organized, ordained, and established. The sooner you do that, the better it is for your whakapapa. Now let me just digress for a little bit. You know what's the biggest, greatest, most incurable disease in the world? Fear. F-E-A-R. Fear. A friend of mine a long time ago in the United States told me FEAR is an acronym for false evidence appearing real. FEAR. What are you afraid of? We're all going to die one day. You want to die of a heart attack? You want to die of a diabetic coma? You want to die in a road accident? No. Die for a cause. I'm going to die too one day. Die for a noble cause. Not for an ignoble cause like sickness and an accident. There's no style. There's no panache in dying like that. Die with dignity. Die for a cause. Die for the Wakaputanga. Die for the Treaty of Waitangi. Die for your rights. Now, I don't mean get into a fight and shoot and maim and kill and no. Keep this fight going. You got the best covenant in the world. You're the only indigenous people who were able to secure such a promise and a guarantee from the clown. There I go again. The point is made. Now, there was a case in Nigeria. I picked this up from the New Zealand Law Report, where the English judge said there is a need to avoid equating customary native rights with English concepts of customary native rights. That was the Amodu Tijani versus the Secretary, South Nigeria, 1921, 2 Court of Appeal, 2 AC 399, Privy Council. Now, this case was cited and affirmed in a New Zealand case called a Ngati Apa, Ngati Apa, versus Attorney General 2003, and the site is 3 New Zealand Law Reports 643, and at page 661, Elias, Chief Justice, said, "The proper starting point is not with assumptions about the nature of property, but with the facts as to native property." Thank you, Chief Justice Elias. You see, the Crown is reaffirming, agreeing, validating, recognizing, endorsing, acknowledging your customary native rights, your ta'onga tuku iho, your usucapion rights. It's clear in case law. Now in 1871, going back into time, in Ray London and Whittaker Claims Act, it was a piece of legislation. Whatever the extent of that right by established native custom appears to be, the Crown is bound to respect it. And the site is 2 New Zealand CA 41. So your Wakaputanga, your Treaty of Waitangi, and your Te Ture Whenua Maori Land Act is your Magna Carta. That is your major charter. That is your whakapapa. That is the beginning and the end of all that you are as a proud people. So remember to tell the Crown, if you're invited to be a defendant in their court, that you got the Te Kute tribal court. And we have prepared the 10 commandments for you. Brother Nephi, you got that. Sister Kathy has sent that to you, and we have posted it in our website in Aotearoa. Don't fight them. Teach them the right things based on common sense, which is very uncommon these days. But the fact of the matter is, you cannot lose when you obey the law of your land. So that is the message for today, part 5 of the law of the land. Always go back to section 2, section 3 of the Wakaputanga, the provisions of the Treaty of Waitangi, and the preamble to the Te Ture Whenua Maori. That's all you need to know. All right? And I urge the young people in Aotearoa to get an education on these 3 crucial, vital, most important law, L-O-R-E, of the land. Thank you. Be blessed until we meet again.